finished Byers last Friday. The recording is up on the website, so if you want to go back and listen to it, that's fine. The assignment that I talked about last week, I'm delaying it a week. We'll look at it today just to talk about what you should be thinking about when you write it out, but it'll be due in a week. Today we do bankruptcy. And I want to make one thing very clear. This is not a course on bankruptcy. So, why is bankruptcy in here? Bankruptcy is in here because most of what is thought about when the drafters wrote Article 9 was the consequences of bankruptcy on secure transactions. So understanding how bankruptcy works, at least superficially, helps us understand why choices are made and how creditors are treated when bankruptcy happens. Most cases litigated about Article 9 are bankruptcy cases. They're not state court cases. They're not, usually there is some litigation, but not much between secured parties that occurs outside of bankruptcy. It's almost always in bankruptcy. Why? Because if the debtor is able to make its payments, there's no need for litigation. And if they can't make their payments, bankruptcy is by far the best way to resolve that. Bankruptcy was created. It's actually in the Constitution. The ability to file a bankruptcy, the idea of bankruptcy is a constitutional provision. I think I'm right in that. And the idea of getting a debtor a fresh start has been around for a very long time. You get overwhelmed by your debts. We need an orderly system to help people get a fresh start. That's the idea behind bankruptcy. That's why we have it. Secured parties have a preferred status in that system because of their security interests. So lenders that take get a lien on property to secure repayment get paid first. That lien makes them a preferred party. The other creditors, the ones that don't have that preferred status, are called general creditors. So the general creditors often get paid pennies on the dollar, if anything at all. If we're talking about personal bankruptcies, it's very common for there to be a no-asset bankruptcy. Individual debtors, when they file bankruptcy, often don't have anything of value that's subject to a security interest, and they have no money to pay their debts anyway. So it's a no-asset bankruptcy, and they're just going for the discharge. Now, you all know as students that student loans are not dischargeable in bankruptcy. There are some debts like that are not. There are certain obligations such as alimony, child support, things like that aren't, I believe, are not dischargeable. But that's not the rule. The general rule is that most debts are dischargeable in bankruptcy. I don't care if you know that. Right? I don't care that you know what is or what is not dischargeable in bankruptcy. I don't care whether you know the ins and outs of how to file a bankruptcy. Irrelevant to this class. Okay, so this is in here because we're talking about the interface of Article 9 in bankruptcy. You got a question?
It is. It's about the student loans. What if it's a private student loan? It's not backed by a federal.
Don't know. Not a bankruptcy person. My suspicion is that it is dischargeable because it's not. The loans that are not dischargeable are the ones that are government, either made by the government or insured by the government. When I went to law school, I took out a lot of loans. Those were all private loans insured by the federal government, so they were non-dischargeable. Now it's the federal government that lends money. It's definitely not dischargeable. It's a travesty, but that's the way it is. The federal government decided that the taxpayer should not support students who are unable to pay their loans back. That's where we are today. That may change, we'll see in the next election. Okay. So what we talk about in class today is what I want you to know. I don't care about knowing the ins and outs of what needs to be in the petition. I included a very quick example of a petition in the lectures. That's irrelevant to me. What I care about for this class are sections 362, 544, 546, and 547. Essentially, the automatic stay, the status as a lien creditor and preferences. Okay? There's a question in here about the fraudulent transfers. You should know that. I would never test on it. I'm not testing on fraudulent transfers.
Could you repeat those sections
Sure.
a little slowly, please?
Well, it's the ones that are in the book.
Okay.
Yeah, it's the one, I'm not telling you anything that's not in the book. But that, I will repeat them. 362 is the automatic stay. 544 is the status, is the strong arm power. 546, preferences, and then 547 has some limitations on preferences. We'll talk about those in class, so don't worry.
Okay,
We
thank
will
you.
come back to that. That's all I really care about. I care that you know that the trustee in bankruptcy has the status as the hypothetical ideal lien creditor. Why do I use those terms? Hypothetical. No such lien creditor could ever exist. The status that the bankruptcy trustee has is impossible, except in bankruptcy. Ideal, in that the bankruptcy trustee doesn't actually have to do anything, but they get this super lien on all of the debtor's assets. The trustee does. Hypothetical ideal lien creditor. The hypothetical part is they lent money, got a judgment, and levied all on the same day. Impossible. Cannot happen. But that's the status that the trustee has. We've seen the section that applies in this when we're talking about the lien creditor status, and that's 9317. So there's an interface between 544 of the Bankruptcy Code, section 544, and 9317. And 9317A is the section that says an unperfected secured party loses to a lien creditor in most circumstances. So that's the analysis we're going to do. Okay? 9317. We also see that the bankruptcy trustee has the ability to avoid preferential transfers, which for our purposes are transfers made 90 days prior to filing of bankruptcy. And in the lecture I reviewed, the fact that a transfer includes the granting of a security interest and payments. So the creation of a security interest is a transfer. Now the confusion may be the filing of the financing statement. The filing of the financing statement can establish the date of the transfer for purposes of bankruptcy. If a transfer occurs during the 90-day window before the bankruptcy filing, so we go date of filing a petition and back up 90 days, if there's a security interest that's granted in that period, it might be a preferential transfer. It doesn't have to be. So we'll review that today. All right, before we go into the problems, let's talk about definitions or concerns that you had with the material. The problems, I think we'll do a good job of talking about what I think is important, but I want to make sure, because I know this is complicated, and I understand this idea of preferences can be a little bit confusing. It's the longest lecture I have of the 3 lectures. Okay. Why is there a preferential transfer avoidance power? Because we don't want the debtor in the period of time leading up to the bankruptcy to prefer one creditor over another. One of the benefits of bankruptcy is that we have an orderly distribution of the assets of the debtor to pay off the debtor's loans. And that would be hindered if the debtor gets to choose who gets the money. Now, you can, as a debtor, you can plan around this. You can say to yourself, I really like First Bank and I hate Second Bank. Pay them a huge payment and then file for bankruptcy 91 days later. People do that all the time. And why would they do that? Well, maybe they're hoping they get to keep the credit card, right? If the bank sees that they're paid off and then the debtor does not file bankruptcy for 91 days, it's not a preferential transfer, they get to keep the credit card. For example, so you can plan around that date. For our purposes, it's the creation of the security interest that we care about. You are advantaged in the bankruptcy by getting a security interest because you get paid first out of that asset before anybody else gets paid. The trustee is marshaling up, collecting all of the assets of the debtor, selling them off, and paying off all the creditors. Pro rata. Everybody gets the same percentage. Whether you're owed $1,000 or $1 million, if at the time that all the assets are sold, we determine that the debtor can pay off 10% of the debtor's debt, then every creditor gets paid 10 cents on the dollar, except for secured creditors. Secured creditors get paid everything that they're owed up to the value of the collateral. So, in the 90 days before the filing of a bankruptcy, if you have an existing debt and you're worried that this debtor is going to file bankruptcy, you can go to them and say, hey, how about you give me a security interest? Is that supported? Is that a legal security interest under Article 9? Already have an existing loan, bank a year later comes and says, hey, I would like a security interest to cover this loan. Is that okay? Yes, an existing debt under Article 1 is sufficient consideration to support the contract that is the security agreement. But that, 90 days prior to bankruptcy, makes that creditor better off than all the other creditors. And so therefore, it can be a preference. So we'll look at that too. Purchase money security interests have special status in this process. What is the automatic stay? It is an injunction that stops all collection activity and any efforts to make your position better as a creditor, which would include the filing of a financing statement. If you were unsecured on the day before bankruptcy, and then the debtor files bankruptcy, the creditor cannot file anything. It's a violation of the automatic stay. It's an injunction against all creditors from improving their situation, except for purchase money secured parties. So purchase money secured parties are allowed to file, notwithstanding the automatic stay. So once again, we like new value. Now, from a systems perspective, that's probably okay because the debtor got something more, and like the estate that gets created on the day of filing the petition, it was made bigger by the acquisition of this collateral. And if we can prove that it was a purchase money acquisition, no other creditors are harmed by that. No one's made worse off, right? The creditor didn't own the car. Now the debtor didn't own the car. Go to the car dealership, buy a new car. Now the debtor owns a car. Car has financing on it, 100% financed. Well, that car wouldn't have been available except for the fact that somebody lent money to the debtor to buy it. So that asset really wouldn't have been there except for the purchase money loan. So no one's worse off because of allowing the purchase money secured party to have a preference and the ability to perfect after the filing of the petition.
It still has to be done within 20 days of them, the debtor getting.
Yeah, bankruptcy it's 30.
30?
Yeah.
That's where I was getting.
Yeah.
confused.
They get 30 days under bankruptcy law. Okay. It's not a class on bankruptcy, but you need to understand these few things because they drive decision-making on how the code is drafted. And so all of these rules actually exist mostly because of bankruptcy. So that's why we spend some time talking about it, okay? But I'm not ever gonna ask a question of was the bankruptcy filed appropriately? Were the schedules correct? Don't care about any of that. And there are a couple of questions I'm just gonna tell you, don't even worry about, that are in the book. But again, I'm using a new book and I read through the stuff again and I'm like, I don't even care about those questions. I would never ask a question about them, so I'll tell you that. Okay? We all good? Did that help? A little bit? Hopefully the problems will help us really sort this out, okay? It's all about timelines. It's all about knowing when things happen. All right. I went up to go print off my notes, and for some reason my notes couldn't print off, so I'm using my iPad here. I will have to constantly turn it back on, I think. Okay. Problem 113. Let's see. All right. Again, I've hit this side pretty hard over the last few weeks, so I'm going to start again over here. Nicole, 112, problem A.
Can I take a pass for today?
Sure, you can absolutely take a pass. Emily,
I would like to.
you would like to take a pass. We're getting towards the end of the semester here, and you have completely given up. Not that you have given up.
No,
You just have other stuff going on, and you're freaking out, you're doing your externships, and you're writing briefs, and whatever. I get it. It's okay. Yes. So Nathan.
113, right?
Yeah,
All right, did I say 112? I meant 113 on page 276. So we have this restaurant that has borrowed money, many unsecured creditors. Can the trustee avoid the bank's security interest under 544?
So I put yes, because you can, and really my reasoning here was just based on the Cali assignments, that seemed like the answers.
So let's just put the dates on the board, because I think that will help us, right? 4/17 is the date that I show that the money was lent, and a security interest was granted in equipment, right? Was it existing equipment? So not a purchase money situation for problem A. 4/18, bankruptcy filing. What didn't happen?
They weren't perfected.
They were not perfected. They were secured, but they were unperfected. Can the bankruptcy court award that $10,000 security interest?
Yes,
Why?
according to, I think it's 544A.
Yep. And 9317A2A. The lien creditor beats an unperfected secured party. Article 9 doesn't say the secured creditor beats an unperfected secured party. It says under state law, if the unsecured lien beats the party, then the trustee wins. Trustee wins. That's it. This is the exact example that I'm talking about. If you're unperfected on the day of filing the petition, you're done. Can they file a petition? Can they file a financing statement on April 19th?
No,
Why not?
because the bankruptcy filing's already happened.
So let's talk about the two sections. You said 544A, strong arm power. That's what it's referred to as. It's the strong arm power. It's the power of a trustee in bankruptcy to avoid an unperfected secured party. The strong arm power also includes the status as a bona fide purchaser for value and also the ability to avoid preferences. Okay. Now, before we go anywhere, I need to see if anybody is stuck on this one. Because I think this is the easiest, obvious example of the effect of bankruptcy filing with an Article 9 situation. You have to be able to do this question in your sleep. You should have been able to do it already because we already talked about lien creditors, but this is where the rubber really hits the road for Article 9. And I want to make sure everybody, if this is still confusing you and you don't want to raise your hand in class, you must see me. Okay.
Why did you say they can't file a financing statement?
Because of what law, Nathan? Why can't they file a financing statement? Sorry, I didn't write it down. That's the strong arm power. Why can't they file a financing statement?
I'm not sure.
What's it called?
Automatic stay.
The automatic stay. Sorry, I did not. Thank you. Thank you for asking that because I forgot that. I'll do the follow-up. Why can't they file a financing statement? Because there's an injunction that says they can't file a financing statement. Who here has done bankruptcy work? Anybody done it for a little bit? How big a deal is the automatic stay?
Pretty big. Once the bankruptcy is filed, yeah, so pretty much everything stops at it.
And what if you ignore the automatic stay? Does anybody here know what happens?
It never came up. Everybody kind of respected it.
Yeah, everybody's freaked out by the automatic stay because there's fines, possible penalties, maybe loss of your status, all kinds of bad things that can happen to you. They don't mess around with this. The trustee 100% will sue a creditor that violates the automatic stay, and 100% the bankruptcy court will sanction you if you do this. You can't call the debtor, you can't file documents, you can't do anything without permission of the court. Yeah.
So just to be clear, in this situation where you, obviously you can't avoid you would still get, whatever that may be, the 10% or whatever, you just won't get you won't get any preference, or you won't get any,
That is a great question.
you won't get the collateral, the value of the collateral.
What happens to this creditor? They become a general creditor. Unperfected secured party on the date of filing of the bankruptcy petition is converted into an unperfected secured party, also referred to as a general creditor. These are all great questions. Thank you. Do not hesitate to ask them. Getting this is important.
So if you're just another random creditor of this person, do you get notice somehow of this bankruptcy proceeding being filed?
Yes.
So that you know to stop?
There's a petition filed, and there's an obligation on the part of the debtor to accurately list everybody that they owe money to. And if a lawyer is involved, they're ethically bound to ensure that the list is correct. So lawyers get in trouble if they get this wrong too. Yeah.
Is the policy behind this that the bank should be underwriting a potentially bad loan? If this guy's this close to bankruptcy, they shouldn't be making any kind of loan to him. I mean, it seems harsh that it's like he takes out this loan the next
Yes.
day he files bankruptcy.
It's harsh.
I know. So
But it's also clear.
I understand.
Yeah. I mean, no bank is confused by this. That's why you pre-file
How often does this happen?
all the time. We have cases in the book.
So how
Millions, billions of dollars lost because people screw this up. It happens all the time. Is an overstatement, obviously. There are so many loans made every year that the vast majority of them are done correctly. But it is in fact the case that every year a percentage of those loans are properly documented. Yeah, that happens. And those people lose their status as secured party.
So as the creditor, it's like file immediately, as fast as you can,
Yes.
before they get out the door. And
Now,
don't make that.
We're going to come back to the preferences in a second. There is a little bit of leeway if you manage to file before the bankruptcy petition is filed. But if the bankruptcy petition is filed, you're done. You're toast. So if you're dealing with a creditor that is financially unviable, file first. Don't do anything until you have your financing statement in place. Okay, question B. What result if the bank had filed its financing statement 2 seconds before the bankruptcy petition is filed? Do you want to take that one?
Yeah. So because it's perfected now, the trustee would be able to, or would not be able to avoid the security interest.
What's the date of the transfer? We're going to do preferences in a minute, but what's the date of the transfer if they file the bankruptcy petition the next day? So they got the loan on the 17th and they file on the 18th, but a second before the petition is filed. What's the date of the transfer?
18th?
No. If you file within the 30-day grace period, the transfer is deemed to have occurred on the date of attachment. Sorry, I jumped ahead. It's a great, I just wanted to see if people saw it. So the transfer date is the key date, right? The date of transfer, if you file within 30 days, is the day of the security interest attaches. If it's filed more than 30 days, it's the date of filing. And that's sucker. Yes?
So that's like unless there's a bankruptcy filing that
No.
cut that off.
Let's remember. What is the date that the trustee gets their, when does the trustee get their status as a lien creditor? The day what?
The date of the transfer.
No, when does the trustee in bankruptcy get their status as the lien creditor?
When they file the petition.
When the petition is filed. So everything we're talking about is if it's before the date of filing the petition, right? It's the date that the petition is filed, actually the moment the petition is filed, that creates the status as the lien creditor. Okay, and so everything flows from that.
So why would it matter, we talked about that 30, going back 30 days,
loan was made on 3/30 instead of April 17th. What's the date of the transfer? Is it a preferential transfer if the filing occurs on, let's say in problem B it says a couple seconds before, so it's April 18th. Loan is made on 3/30. What's the date of the security interest coming into existence? 3/30. What's the day for bankruptcy purposes of the transfer? 3/30, right?
So could it still be voided because of this 90-day rule?
It's not a preference. New value, and it was.
I thought you said the creation of the security agreement could be a.
It can be, but it's not automatically.
Okay.
We have to do analysis. It may be. Yes, it may be. This is why pre-filing is so important. If you pre-file, as soon as it attaches, you're perfected. So you're done. You don't have to worry about when it happened. It happened when you. So if you make a loan and you file on the same day, you're totally cool. As long as you file, you can never screw this up. If you file before the security interest attaches. So if you pre-file and then you got make a new loan to somebody, you can never have a preference.
So this is all just looking at it from 544?
Yes.
Yeah,
We're looking at it from the strong arm power.
yeah, okay.
Yeah. We haven't done the preferences yet. I'm just saying, what's the date of the transfer? Okay. If you file within 30 days, for bankruptcy law purposes, the date of the transfer is the date of the attachment.
But like, why does that matter against the trustee if you file and perfect your interest before they file for bankruptcy?
We haven't done preferences yet. If you screw the dates up and you go more than 30 days, it could be a preferential transfer. I'm saying if you don't, you're fine. Yeah. Yes, ma'am.
Maybe it went over my head, but where did the 30 days come from? Is that a grace period?
Yes,
or-
it is
okay.
absolutely a grace period.
So
546.
546?
Yeah.
Okay.
We haven't done a problem on it yet. We'll do it. Question C. Part C. You want to do that one too?
Yep.
Nathan, here we go. Coming in.
Go ahead,
So-
Nathan.
I said that, just based off the, provision of the code they have below, the filing of the bankruptcy petition would not cut off the 20-day grace period.
And just to help everybody, what section of the bankruptcy code should we look at to get the answer to the question?
546B1A.
Yep. 546B1A and 9317E, right? The lien creditor does not beat a purchase money filer. So therefore, the bankruptcy trustee does not beat a purchase money filer. Ever. Now remember, we're talking about the bankruptcy trustee, so there are rules about bankruptcy that are a little bit different. Bankruptcy rules govern the trustee in bankruptcy.
Because this is a PMSI
Yeah.
on commercial goods, like, they do have to still file within that 20 days, though, correct? It doesn't like perfect automatically.
Perfect automatically, unless it's, what kind of goods does a purchase money security interest perfect in automatically? Yeah.
So if.
This
they-
is equipment, so it does not perfect, they have to file.
And I'm pretty sure of the answer, but I just want to check with you. So if they, on day one, they create the PMSI and the commercial equipment, day two, the debtor or the, I can't remember the name of the guy, but the guy files for bankruptcy, do they still have the 20 days, even though that period for the trustee has begun?
Yeah. Yep.
So earlier, I don't know if I missed it, but so we were talking about the PMSI in 20 and 30 days
Yeah.
for bankruptcy. So is that right here or?
So if you take a look at 362 is the automatic, well, so purchase money security interest is covered in 946, right? Close the section of the code on this. So we look at oh, there we go, wrong section. Statute 546B. The rights and powers of the trustee under 544 of this title are subject to any general applicable law that permits perfection of an interest in property to be effective against an entity that acquires rights in such property before the date of perfection or provides for the maintenance. So those two together, right, they limit the effect of the automatics, of the strong arm power.
Okay.
Yeah. The case, so we've done all parts of 113. We'll move on, we'll start talking about more stuff, we'll add layers to this. The case is an example of you screw up and you lose. So what's the problem? The security interest refers to a promissory note that does not exist. And the bank argues, but under the parole evidence rule and the composite document rule, we're allowed to bring in evidence, right? Because you've got this security agreement that refers to a note that doesn't exist. That's an ambiguity, right? There's supposed to be a security interest, but this note doesn't exist because it's not, there's no December 13th note. If it were a litigation between two secured parties, yeah, all those rules would apply. You could bring that information in. Not against the bankruptcy trustee. No parole evidence allowed. If you're not perfected, if it's not, the paperwork is not right, you lose. No one's confused by the existence of this note. Everyone agrees that the December 15th note is the December 13th note on the security agreement. Everyone agrees to that. They still lose. Don't care. That's how bad it is. If you don't do your paperwork right, very unlikely that the court's going to have 1 ounce of sympathy towards the bank. Do your paperwork right or become a general creditor. That's what the case is referring to. Okay? Everybody good? All right, problem 114. So Ben, why don't we work through it? Let's put the dates up on the board though, right? So there's an $80,000 loan, right?
Yeah.
What's the date that that's made?
June 8th.
Right, so there's an $80,000 loan. And what else do they have?
Business corporation gives O&B a security interest worth $100,000 on equipment.
Okay. Was it equipment or is it inventory? I'm sorry, I wrote inventory, but maybe I have that wrong. It's equipment, yeah. Security interest in equipment, and how much they have in equipment?
$100,000.
Worth $100,000. Are they over or under secured?
Over.
Yeah, the debt is more than the amount of collateral. Great. When do they file the financing statement?
July 18th.
And when's the bankruptcy filed?
July 9th.
Okay. What's the first question in the book?
Can the trustee destroy O&D's secured position and turn it into a general creditor under the theory that the delayed perfection is a preference?
And your answer?
I said that it's not. It didn't have to meet all 5 of these criteria to be a preference.
Okay.
And I would say that they weren't insolvent when they made it, because they gave them a security interest in more than what the loans were.
Okay, but it's the debtor that has to be insolvent, right?
Yeah.
So just because they have $100,000 in inventory, what if they owe $1 million? Yeah. But that's a good point, right? There's a 5-part test for preference. It's a preference if 5 things. So if they're not insolvent, it's not a preference. But let's say they are. And by the way, there's a presumption in the code that everyone is insolvent 90 days before they file bankruptcy.
Okay.
Is that a good presumption?
Yeah.
I would say so. Right? You don't go, Hey, I feel like filing today. I'm loaded, but I'll just file for bankruptcy. With one exception. Don't write this down. Not part of this course. Little transactional tip. Sometimes you make a company you're buying file for bankruptcy so you can solve all of the existing debt issues. Get it all right, orderly disposition of the assets and collateral of the party. You make the target company you're going to buy file for bankruptcy. What does that do? It gets a discharge in all the debts of the company. And then you buy the company debt-free.
You're sneaky.
That is sneaky, and it's done all the time now. It's now a very common practice. If you're buying a company that's a little bit questionable, you're not sure where they are, you put them into bankruptcy and then acquire them. The creditors love it because they get paid, right? They're getting a check because of the bankruptcy. The acquiring company is going to write a check and pay everybody off. But what disappears are all of the unknown debts of the company. So potential tort feasors that are out there. You don't know about them. Once the discharge happens, they go away. So you get this company free and clear. So it's an acquisition technique that companies use to protect themselves against acquiring a company that has debts they don't know about. Yeah. Don't write that down, not part of this class. Practice tip for those of you who want to become corporate attorneys. It's not uncommon that this happens. Okay, so assuming they're insolvent, can the bankruptcy trustee use its strong arm power to avoid this transfer?
No, because they filed the financing statement before the bankruptcy was filed, so it's already perfected at the time of bankruptcy.
They filed beforehand,
Mm-hmm.
okay, but what? Okay, so let's talk about what is a preference. It's a transfer to a creditor that makes them better off than they were before during the 90-day period. So one part of the test is, are they better off than they would have been if this had been a Chapter 7 liquidation? Would they be better off in this case?
Yes.
Okay. Is this a preferential transfer?
Yes,
Why?
because they're receiving more than they're running out.
On this date, are they perfected secured party?
Yes.
No, here.
Oh, no,
Why? What's missing?
just money.
If you get a security interest 90 days before the filing of a financing statement, is that a transfer for purposes of the preference rules?
Yes.
It is. It may not be avoidable, but it is a transfer. Okay? It may not be a preferential transfer, but it is a transfer. It's a transfer of an interest in property. The security interest is a transfer of an interest in property. That you can write down. A security interest is a transfer of an interest in property. Is it a preferential transfer that is avoidable by the bankruptcy trustee? Different question. Okay, what's the date of the transfer?
The eighth.
That's when Article 9 says the security interest attaches. When does bankruptcy say the security interest attaches?
I don't know.
This is gonna drive me crazy. This is why I always print them out, because this part I hate. Was having to unlock it. What's the grace period?
They're stuck with the July 18th because they waited more than 30 days.
Okay, now, in order for it to be a preference, you have to meet all of those conditions. One of them is it has to be on account of an antecedent debt. Is this a transfer on a day for a debt that already exists? What's the debt that already exists?
80 days.
Here's the loan already existing on the day the transfer occurs. Is this transfer of an interest in property on account of a pre-existing loan?
Yes.
Antecedent means existing, right? Old.
Okay.
Can the bankruptcy trustee avoid this?
Yes.
There is the possibility of a 547C1 making a claim that it's substantially contemporaneous, and I'm going to tell you For this class, we're not even gonna worry about that, okay? I don't care about that analysis. If you ever become a bankruptcy lawyer, you can worry about it. We're not worrying about it for this class. It's not substantially contemporaneous.
But if it was within 30 days, it would be?
Well, if it's within 30 days, what happens? What if they file on 6/18?
Then
What's the date of the transfer?
then they can
6/8.
say 6/8.
Okay, that's fair.
Was it new money? New value, they got $80,000, they lent a new amount of money to the debtor, got its security interest, that's the transfer of the interest, and it happened all at the same time, not a preferential transfer. Yes,
So the 30-day window is to avoid an antecedent status?
yes. Yep. It's the grace period. Bankruptcy creates a grace period. Article 9 doesn't. Bankruptcy does. This is a bankruptcy grace period. This is not an Article 9 grace period. 9317E, PIMSY 20-day grace period, that's an Article 9 grace period. The 30-day relation back rule for determining the date of transfer, that's a bankruptcy idea, okay? So what I'm telling you about here is bankruptcy, not Article 9.
What was the answer?
If ONB had perfected on June 8th, but the debtor made some extraordinary payments to ONB during the 90-day period before the filing of the petition, could the trustee use 547 to make ONB pay the money back? This is the crappiest part of 547. All right? You're paying your bills off. The money you pay to people, the bankruptcy trustee can go and say, I want it back.
I'm sorry, can we go back to that?
Sure.
What was the conclusion? So
It's a preferential transfer because it happened outside of the 30-day grace period. The date of the transfer is
Okay.
deemed to be the day you file the financing statement. More than 30 days, so you can't relate back to the date of creation of the security interest. Therefore, the date of the transfer is the date of filing. Therefore, it's a preferential transfer because the loan already existed on the day that the security interest is deemed to have been transferred. I said that very, very fast.
yeah, you did.
That's the New Englander in me, right? So let's start here. For it to be a preferential transfer, it has to be a transfer. So let's start right there.
Okay.
The creation of a security interest is a transfer of an interest in property. That security interest can be a preferential transfer if the perfection occurs later than 30 days. Why 30 days? Because the bankruptcy code gives a creditor 30 days to get to the Secretary of State's office. Okay, that's the only reason. If they file outside of the grace period, then the bankruptcy code says that's the day the transfer occurred. So now you have two dates, July 18th and June 8th. On July 18th, we deem the transfer to have occurred on account of an already existing loan.
Which would make it antecedent, and then it can be avoided.
Yes.
Okay.
You've got, that's it, you've got it right. That is exactly the right answer. Michaela, that is exactly the way you would describe this.
And then, so I don't want to get sucked in.
No,
but
this is good. I want you to make sure you understand this.
Is there a different rule for PMSI?
Yes.
Okay,
We haven't done that yet.
okay.
But yes, there is a different rule. We love purchase money security interests, both in Article 9 and in the bankruptcy code, because it allows the debtor to buy stuff. And we want to encourage people to buy stuff. And from a theoretical perspective, the debtor acquiring new stuff doesn't make any creditor worse off,
Yeah.
right? The estate gets bigger, so the loan attached to that newly acquired collateral doesn't affect who gets paid. Yes?
Didn't you say one factor is if you're better off than you would have been?
Yes.
So can all the other stuff happen, but you're not better off and it's not a preferential transfer?
Well, but secured parties are better off in bankruptcy, right? You're better to be a secured party than a general creditor. So you're better off because you have a security interest.
All right.
Yeah. Now, what if they had filed on, or tried to file on the 20th? How does that change any of this? They're not a perfected secured party, so you don't need to worry about a preference. If they attempt to file after, unless, and we talked about purchase money is different, but the automatic stay prevents you from filing after the date of the bankruptcy filing. If they had not filed, if this had not happened, right, this is gone, they're an unperfected secured party, they lose under 9317A2A. Okay, so we don't have to worry about preferences. If you're unperfected on the day of the filing of the financing statement, and you're not a PIMSI lender, purchase money secured party lender. I can't tell what I should. My professor called it PIMSI. It sounded fun. But Professor Novo always said PMSI, very serious. I like PIMSI, but anyway. PMSI, right? If you're a purchase money secured party, the automatic stay does not apply to you if you file within the 30 days of the bankruptcy code. That's a bankruptcy rule.
On this timeline, if, let's say bankruptcy was filed on like 6/10.
Yeah.
And there was a security interest, but no perfection, or no filing yet?
Yeah, so they file, you're saying they file here.
Yeah, do they just lose the 30-day window?
Yes, because they can't. The automatic stay prohibits you filing the financing statement. Yes. Don't even have to worry about preferences. You only have to worry about a preference for someone that is perfected on the day of filing, but they became perfected during the 90-day window. Okay? That's the only time you have to worry about the preference rules. If you were perfected before the 90 days, don't care. If you're unperfected on the day of filing the petition, you're unsecured because of the strong arm power. The only people we care about in this situation is got your security interest and you filed your financing statement within the 90-day window. If you do it within 30 days of the security interest, you're cool. It relates back to the day of the security interest. If it's after the 30 days, then it's a preference for our purposes.
So if it's not perfected, that's when we will use the strong arm power?
544A.
Okay.
Yes. You're unperfected, lien creditor beats you, you're done. Yep.
But that's the date of the petition.
Yes.
Does that relate back? That doesn't relate back 90 days. That's the date of the petition.
No, it's just the day of the petition.
Got
The
it.
day of the filing of the petition establishes the 90-day window for preference purposes.
Right.
And also fraudulent transfers, insider transfers, things like that. But it's the day that the trustee becomes the lien creditor. And that's the only day that they become the lien creditor. Okay, so I hate questions about, well, was that 30 days or 31 days? I don't write questions on exams where it's unclear if it was 30 days or 31 days or 32 days. I try to write things so it's very clear, like this one. June 8th to July 18th. That's a month and 10 days. That's clearly not 10 days, not 30 days, all right? I'm not gonna test you on, can you figure out exactly, okay? I'll probably make it, I can't guarantee that I won't screw up, but assuming that I'm thinking properly and I haven't had a lot to drink the night before I write the exam. I don't write exams that way. Okay? I will make it obvious what the dates are, okay? And the 90 days. I'm not gonna create a problem where they have one in the book, like it's March 1st and then May 28th. That's 90 days. All right, I'm not gonna be cute like that. It's gonna be July 1st or April 15th. It's gonna be something that you're gonna be able to look at it and go, yeah, that's clearly either not 90 days or it is 90 days, okay? I'm not gonna trick you on that. No interest now, I just need you to know you know the rules. I don't think the bar examiners do that either. All right. Finally, again, assume that ONB had perfected on June 8th, but the collateral was only worth $60,000. Would the routine payments made to service this debt be preferential? I don't think I'm going to write a problem on this, but the answer to this is very clear. There is an exception for routine payments under, and let me just get the code section. It is section, there we go. 547C3, right? I think I got that right. No, that's the wrong problem, sorry. 114. Yeah, C2, sorry. Thank you. C2.
Can you explain the difference between that and the one before about extraordinary payments? What does that mean?
Oh, if it's not in the ordinary course of business. So if they're not just routine payments that you're just every month, you're just
Okay.
paying your bills as they come in.
So just.
But you go, ooh, I got an extra $5,000, I'm gonna send that in.
Okay, then those can be,
Yes.
okay.
Yes. But again, that's more of a bankruptcy concept than an Article 9 concept. I'm not testing it on bankruptcy. That's why, not that it's not important, it is. But this is an Article 9 class, it's not a bankruptcy class. The question of whether the payments are preferential transfers on a loan, I'm probably not gonna test on it at all. Because that's just too much bankruptcy rules for me. Okay, I just want you to know the dates of when the lien creditor status comes in, when the preferential process works. Payments on loans, Okay. Problem 115, Natalie.
Okay. I'm trying to remember here, so,
All right, well, let's chart it, let's do the dates. I'll put it up, I'll leave that one up and I'll go over here now.
so there's a loan,
So I think that, doesn't it start 11/1?
yeah,
Yeah, I just wanna make sure we have the dates, because I think the dates are important to understanding how this works.
the loan is for $1,000 and it's to purchase something. And then.
Kermit's buying a banjo,
And
all right?
then,
And
yeah,
he signs a security agreement. Does he own the property yet?
no, he,
So it has the security interest attached
no,
on November 1st.
no.
Okay.
But then on the 15th, he buys it. And then the bank files the financing statement on December 5th. So they did that, wait a minute. Is that
And when is the bankruptcy filed?
The bankruptcy is on the 6th.
Okay. Okay. Is, under Article 9, is the bank, is it, what is it, what was the name of the bank, Piggy First, something like that? Is it perfected on December 5th? Under Article 9, they are perfected on December 5th. Okay. What's the 90-day window for preferential transfers? How far back would we go? September 6th or so, right? So the 90-day window probably starts on September 6th. Okay, so has this occurred during the 90-day period preceding the bankruptcy?
Yes.
Okay, so it's possible but not guaranteed that this is a preferential transfer. The security interest is a preferential transfer. Okay, the day that the security interest attached was the day, right, for Article 9 purposes, was here. Okay, so let's do the analysis.
As to whether or not they
Can the
Wait.
bankruptcy trustee void the creation of the security interest by claiming that it's a preferential transfer? That's the way we would ask the
So
question.
I put no, if it's because it's a PMSI.
Ah, great, this is the PMSI situation, right?
So, yeah, so that.
So what's the day of what's the grace period that starts running under bankruptcy law?
30 days, let's see, the trustee may not avoid a transfer that creates an SI in property acquired by the debtor that is perfected on or before 30 days after debtor receives possession of the property.
Thirty days. 30 days has September, April, June, and November. November has 30 days, so therefore 12/15. Yeah, do that with your. Do you know the test with your knuckles? You know, you don't know this? Okay. Ask your colleagues if you don't know it. You don't know the little ditty. So the 30 days from the date of possession would be 12/15. Wasn't perfected within.
Yes.
And that's the purchase money security interest preference. Now, do we have to worry about the automatic stay?
No.
Because the perfection was done before the filing. Automatic stay is not an issue. No 362 problem. okay? Because they filed the financing statement before the bankruptcy filing. So we don't even have to worry about the automatic stay. All we have to worry about is the preference. Is there a preference? No, because, now, did the filing occur more than 30 days after the security agreement was signed? Right? That's more than 30 days. But we don't care about this. We care about this. We care about possession. So the key for the purchase money security interest is that the day that we have to worry about is the day that the debtor receives possession. Anything else in this problem?
Yeah, then it.
What if it was just a regular loan?
Yeah, a loan with a after acquired,
Yeah, after acquired property clause. And do you need the after acquired property clause?
No, I don't remember.
So what is after acquired property?
That it will attach to the security agreement when you get it later?
Yes.
Up to, well, yeah, it'll attach.
Not up to anything.
Yeah, okay.
The after acquired property clause is a clause in the security agreement that says this agreement, this security interest covers equipment. Well, first of all, Kermit's a performer, so it's equipment to him. It's not a consumer good. It would cover equipment acquired now or any time hereafter. Now owned or hereafter acquired. So normally the language you would see. So if you have that, does the security interest cover newly acquired equipment? Yes. Great. Okay. Do we have a problem?
Yeah, I think so.
Why?
Because I think that is preferential under 547E2.
What's the date of the transfer? Was the financing statement filed within 30 days of the date of the security interest attachment?
Yeah.
Yes. Right? That's 25 days, I think. 20 days, that's 20 days. So that's 20 days. Great. Not great. That's the date of the transfer, 11/15. When was the date of the loan?
11/1.
Is this an antecedent debt?
Yeah.
Yes. Sorry, preferential transfer, done.
So you don't get the benefit of the PMSI.
Right. Was there a security interest on November 1st? Was there a security interest, don't ask me any other questions. Was there a security interest on November 1st? No! What three things have to exist for there to be a security interest? Value rights agreement. When did Kermit get rights in the collateral?
When it was delivered.
This is the date of attachment. That's the date of the transfer. Yes, it's within 30 days of the filing of the financing statement, but it doesn't change the fact that the date of transfer is the date the security interest comes into effect, which is on account of a pre-existing loan. It's a quote from what movie?
I don't know.
Oh, come on! Bad farts. Greatest movie ever made. Caddyshack! Greatest movie ever made.
Never heard of it.
Yeah, that's pathetic. I understand. I tried to show it to my kids. They're like, "Can I leave now? You think this is funny?" They did that with Spinal Tap. Also a great movie. My daughter was sitting there going, like 20 minutes into the movie. Can I go? This is not funny. Okay. I get that.
So, back to the PZ.
What was that part in the beginning?
If he had gotten the banjo, like you moved everything back a day, but they still filed on 12/6, would they have 20 days to file because they had filed the bankruptcy in that?
Yeah, but remember, bankruptcy rules can be a little different. Purchase money secured party, the avoidance power for a preferential transfer, you get 30 days under the bankruptcy code.
But what I'm saying is, say they filed bankruptcy before they filed.
Oh. Could they use, the problem there is the automatic stay.
Yeah, the.
Can purchase money secured parties violate the automatic stay? And the answer is yes,
No.
they can.
But do they have 20 or 30 days?
20, because it's, what does the state law say?
And that would run from that 11.
Yeah, automatic stay is different than preferential transfers. Yes. 362 is, can you do anything? And the answer is no, unless there's a system under state law that would allow you to beat the secured credit, the lien creditor. And there is 9317E. Yes. We're having so much fun today, aren't we?
Okay, does the, I
Life
understand
was
that
so
there's
evil.
30 days, I get the difference for the bankruptcy stuff, but like the 20-day PMSI period, did that come into play here at all?
No,
Like, to get the benefit?
because under 9317, okay, were they perfected on the day of filing the petition?
Yeah.
So the strong arm power of the lien creditor doesn't apply, right? If you're perfected on the day of filing the petition, you're perfected. So the strong arm power doesn't apply. 9317A2A, the lien creditor does not beat perfected secured parties, period. We don't care how and when you became a perfected secured party for purposes of the
Okay.
lien creditor status.
Yeah,
Okay.
that's.
This is
getting
this
those-
is the preferential transfer rules, different set of rules.
I keep getting those mixed.
Understood. If you're unperfected on the day of filing the petition, do you lose to the lien creditor? Yes, unless 9317E allows for a filing, and then the stay doesn't apply, and you can file within those 20 days.
Can we go over it one more time?
No.
on this? Can we go over it one more
Sure,
time
of
on this
course.
case, or on this question?
Yeah.
Why, you said it is a.
The preferential transfer, but it's not. The purchase money transfer is fine.
Just the purchase money transfer, not
Yes.
necessarily if it wasn't a purchase money
Yes.
transfer, then it would.
Yeah, and the problem is, on November 15th, when the day the security interest attaches, right? We don't have to worry about the 30-day rule because the filing was done within 30 days. We're cool on that. But November 15th is still the day that the security interest attaches, and it's the security interest that is the transfer, okay? The filing tells you what the effective date might be, but the transfer is the creation of the security interest. The security interest was created on November 15th because under Article 9, you don't have a security interest until there's value has been given, $1,000 loan, there's a security agreement, and the debtor has rights in the collateral. Debtor did not get rights in the collateral until November 15th. How cruel can I be on this exam? I can be so mean. Yes. I love this class. Love it with a passion. What's Halloween? Come on.
So the bank has not signed the security, well, I guess they wouldn't,
Yeah. Okay. This is just a review of the concept of when a security interest comes into existence. It's the day that all three things happen: value, rights, and agreement. Security interest attaches. You will never go wrong unless I tell you, don't worry about it, it's a perfected security interest, and I give you the date. If I just tell you when things happen, you should always tell me when the security interest attaches. Okay? If I say, on September 1st they did this, on September 5th they did this, on September 10th they did this, don't tell me when the security interest attaches. For bankruptcy purposes, it's the date of the security interest that is the transfer, but there's a special grace period. If you file a financing statement within 30 days, it's the day it attaches. If you blow the 30-day grace period, then it's the date of filing the financing statement, the later date of filing the financing statement. So delaying the filing of the financing statement is poisonous to the creation of a perfection of a security interest when the debtor goes into bankruptcy. If you wait too long, you can lose your entire security interest. Even though you were perfected on the day of filing the bankruptcy, the preferential transfer rules allows the trustee in bankruptcy to come back and go, sorry, you lose. That was me taking security interest away. There was a hand up somewhere. I want to make sure we're all good. We only have a couple more questions. 116, don't worry about. I'm never going to ask a 116 question. Hate that question. I read it and I go, what? Don't care about it. That's a bankruptcy question. It's not an Article 9 question. Okay? 117. All right. We don't have a lot of time left. Emily, how are you today?
Well, I was prepared for 116.
Oh!
No, I'm kidding.
Sorry.
I'll do it.
Sorry, I should have said that beforehand. I hate 116. It asks a weird question that I don't think we need to know. Again, if you take the bankruptcy course, 116, great question. Not this class. Yeah. So we're talking about the floating lien now, right? So we have this thing. What is a floating lien? Do you know what that is? Or do you need me to define it?
Well, you just, well, go ahead and define it in your.
So floating lien is when a creditor has a line of credit that covers changing collateral. So you have, the lien sort of floats over the collateral, but they buy and they sell and they dispose of collateral and it comes in and it comes out. And it's not on set collateral. So that's problem 117, right? There's like, inventory is a great example of when you would have a floating lien because inventory changes over all the time. Accounts, floating lien. You just say, I have a security interest in inventory, and the understanding is that that means inventory whenever acquired. Okay? All right. Let's say they perfected a security interest in inventory, which owed the bank $28,000 on March 1. The inventory was worth $8,000. So I'm going to erase this one now. Collateral's worth $8,000. What's the next date?
The 28th.
Of?
Oh, May. You filed for bankruptcy,
Yes, how much is it worth then?
20,000.
What's the question?
What can the trustee do about the bank's claim?
So on this day, they owe $20,000, right? That's the amount owed. And they have a floating lien on the inventory, or whatever it is. Are they under or oversecured on March 1st? Yes, they're undersecured. On the day of filing the bankruptcy, are they, so they'll get paid in full. Are they better off? Are they better off on the day of filing the bankruptcy than they were 90 days before that?
Right.
How much are they better off by?
12,000.
Okay. This is how you do the math. They're better off by $12,000. So the bankruptcy trustee goes, nope, you don't get access to collateral worth $12,000. You ask two questions. What is the value of the collateral on the day of filing bankruptcy? And what is the value of the collateral on the day 90 days before that? Which number do you pick?
Can you repeat that?
You ask the question, what is the value of the collateral on the day they file bankruptcy? And what is the value of the collateral 90 days before that? And what number do you pick?
The lower one?
The lower number. And if the value of the collateral has increased, we don't let the secured party take advantage of it. Essentially what has happened is they have this $20,000 debt that hasn't changed, but the debtor acquired $12,000 worth of collateral, not using a loan from them, right? This is not, right, it's the same loan, right? No, nothing has happened. The loan has stayed the same. They haven't lent any new money. There's no new money in problem 117. So the bankruptcy court says you're only secured up to the amount of the value of the collateral 90 days prior. Well, you look at those two numbers and you pick the lower one. What if the bank first loaned 20,000 on May 1st, when the inventory was worth 12, though worth 20 when the petition was filed? Does that change your answer?
You already, so they had 20,000, so this is.
So the other example is they get a loan for 20,000 on May 1st, right? And what's the collateral worth?
12,
And what's the collateral worth on the date of filing the bankruptcy?
20.
So 528. Are they better off? Are they over or undersecured on May 1st? They're undersecured by $8,000.
Yeah.
So what happens is you go 20 minus 12, can't get access to 8,000. Okay? So floating liens, you have to do a little bit of a calculation. Now, what is the case about? Who has the obligation under the bankruptcy code to prove what the balance is?
The trustee.
Trustee in bankruptcy. What was the problem for the trustee in bankruptcy?
They were commingling the funds.
Right.
They weren't entirely sure what payment for the loan, if that was from the proceeds of that inventory.
Now, the key, I think, to this case is on the first page of the case, 293. How did the creditor lend money? Under the loan agreements, this is at the bottom, TFC extended credit to Smith's by granting approval to various manufacturers. After receiving approval, the manufacturers shipped the merchandise to Smith's. Was there always new value given by TCFC to acquire the collateral? Yes. So every time Smith's got a new shipment of collateral, they had also increased the amount of the loan. So they went together. There was new value always given. The commingling problem is they can't prove where the money came from. So they could have been under or over secured. It's not clear. But the trustee in the bankruptcy has the obligation to prove that the money wasn't used to pay off the loan. Their money wasn't used to pay off the loan. Sorry. The collateral the sale of collateral, the proceeds from the sale of collateral was used to pay off that collateral, that loan. They couldn't prove that, but the trustee in bankruptcy had to prove that. So they win because there's no proof that at any point in time they were undersecured. So the floating lien problem of 117 is only a problem when the debtor is undersecured. The creditor is undersecured. If they're always oversecured, don't care about the payments. Does that make sense? 118, fraudulent transfer. Transfers to his wife. I'm not going to test on that. But it is something to know. If you create a security interest for the benefit of an insider or someone close to you, then that can be there's a 1-year window of opportunity. It could be a fraudulent transfer. We could undo that security interest so the window gets bigger. And the fraudulent transfer aspect of it is we don't care when you filed or did anything. You gave the security interest to an insider, somebody who is trying to hide your assets for you, right? The assumption here is he owes a lot of money, so he gives a security interest to his wife, and that's like giving the security interest to himself. And so therefore, it's avoided as a fraudulent transfer. So that's problem 118. Okay, so for next week, we're doing proceeds. Hopefully proceeds won't confuse you as much as this stuff did, but it probably will.
I'm not confused anymore.
The problem that I posted in this week's assignment, write it up. I'll make a place to hand it in for next week. Just write up your answer, and we'll talk about it in class, okay? I have also found an old exam with an old grading sheet. I believe I have the grading sheet. And I will post that too, so you can see a couple of questions I've asked in the past about secure transactions. Okay?
Do you have time to go?
Yes. So, Kermit the Frog and the Banjo. Because